Been the hearings. Cliff Bolger wishes to send in his apologies. He has taken ill. So we're here this afternoon to hear from Hugh Gardine, who has lodged a general submission to the plan submissions. Hugh, you will know Glenys, the councillor, and Maria Bartlett at the end there, who is an independent commissioner. And the lady over on the far side is Victoria Woodbridge, who's from the property group, who are assisting with the plan review. And you met Lindsay Crazy Wolf earlier, who is our admin person. So we have in front of us the submission that you lodged, which dealt with some general matters. And so we're in your hands for your presentation, and thank you for coming along today. Yes, and I'll get you to push the little button on the thing there to turn it on. Good.
So this isn't really my submission for you to have read and understood before I present, because I want to present this submission. So
yes.
Is that all right?
Yes.
Do I start? It was reported recently in the media that the Gore District Council had overspent on district plan contractors and consultants costs by $813,000. It illustrates to me that council's poor financial management, their inability to stay on budget, and assumption, well, ratepayers will stump up the shortfall. Not one councillor is blowing the whistle. The other, whilst I know most of you commissioners, I do note that Councillor Hovell, previously a planner, now a commissioner, presumably shortly to be a councillor, is considering submissions. Is there yet a conflict of any sort? And if not, how not? The draft on the significant areas section of the plan is derived from the previous cultural and landscape assessment plan adopted by the Council 2021, with threads back to the Treaty Ngāi Tahu Claims Settlement Act, perceived customary tribal authority, and other embedded assumptions, including spiritual qualities of natural resources. The exclusive recognition of customary tribal authority over all of the district and the application of the RMA needs to be suspended, and Council acknowledges the present government's intentions to reset and rewrite legislation that will affect the ultimate outcome and content in the district plan. The district plan, and by extension the council, has been lazy, using the exclusive relationship with Runanga to write the draft without wider consultation from the outset. The district plan is meant to be forward-facing and manage the use of resources and control, but not stifle development in the interests of all residents, and that is missing in the plan to date, especially in this section. No one is questioning the need to protect sites of archaeological importance, the Falls of Mataura, the Tutorau battle site, but ovens and adze and a gravel pit hardly qualify for recognition. Tutorau was not Culloden, and although it's got a monument about the same size, and I note scant regard for historic or existing customary rights were afforded my forebearers from Culloden. That is life, and histories are written by the conquerors. The Ngāi Tahu Claims Settlement Act itself has a section on limitation of rights that states neither a statutory acknowledgement nor a deed of recognition has itself the effect of granting, creating or providing evidence of an estate or an interest in or any rights of any kind whatsoever relating to a statutory area. And I encourage you not to cherry-pick legislation to embellish an alternate narrative. The Land Transfer Act and the Land Act lay out the rights given with the transfer of and holding of freehold and leasehold title, and it is to grant peaceful and exclusive occupation of lands described on the title to the owner in fee simple. The rights, but also responsibilities, ensure that exclusive use, and it is expected that the Gore Council will respect the issues around ownership. You have to stop the possibility of compromise if any activity currently allowed be denied owners and ratepayers in Gore District that has freehold title and impose additional consenting costs in future on them. It is further submitted that there is a real possibility of local body amalgamations that will render any district plan useless, so it behoves you to align our plan roughly with that of our neighbours. Council needs to reaffirm the contribution of all settlers to the development and establishment of the Gore District. Regardless of their origins, the contributions of settlers to land development, schools, churches, and district and township amenities are due to the foresight, hard work and diligence of those settlers and their descendants. We are one people. This is also confirmed in the UN Declaration of Human Rights. People of all minorities, regardless of creed, colour and ethnicity. The planner says in the media that in the Treaty of Waitangi, the Council has a responsibility to involve Renanga in development of the district plan. I brought a copy of the treaty with me, and it says nothing of the sort. I submit that the sentiments in the plan need to reflect that government is to govern, and this includes local government, is to govern for all New Zealanders, that government will respect and honour individual property rights and ownership, and all New Zealanders are equal under the law with the same rights and duties. You have a responsibility through the compilation of the plan to all citizens and all immigrants who live and contribute. It is important the district plan reinforces those sentiments and is a plan that inspires more people to come, work and enjoy the landscapes and amenities equally like we do. Thank you.
Thank you. Any questions? You raised, Hugh, the issue of aligning with the adjoining plan. Southland District Council has been quite active in the submissions it's lodged, where it's highlighted some provisions that across the boundary usefully can fit with theirs. In a couple of cases, their submission says we prefer the approach in the Gore plan, and when we come to change our plan, we'll follow suit with similar sorts of provisions. Progressively over the last few years, councils have been working and getting closer together in terms of what the plans look like. You raised the issue about potential conflict for myself, and it's something we've taken advice on. And those chapters that I did work on as a consultant for council, I am not part of the hearing panel. So I'm stepping back from those ones where there could be a potential conflict. Councillor Dixon here was a member of the working party that actually drew together the plan, and what the courts have said is that as a councillor in preparing the plan, the matters you take into account are different from when you're considering submissions, and as long as you come with an open mind, then there's no conflict from having been involved in the process earlier. So both Councillor Dixon and myself come with an open mind to hear from all of the submitters and consider the best way forward. Anything else?
So am I picking up that the majority of your what you bring to us today is focused on the sites and areas of significance to Māori? Is that the main thrust?
That's the only subject that I've addressed today, and that's the only topic that I raised, I think, in my intimation that I wanted to submit.
Yeah, so I was just checking in the, because you lead out that second paragraph with significant areas, and I just wanted to check because there's different kinds of significant areas, but as I was going through, I was like, well, I'm sure that's, you're only referring to the sites and areas of significance to Māori.
Correct.
So that one, that hearing's due down the track?
Which one?
The hearing on that chapter of the plan is not today's hearing, it's later in the year or later on in the process, but that's, yeah, it's just to let you know that...
Do I have to come back?
You don't have to come back, it's just to let you know.
I just emailed to see if I was behind in the submission process, and I was given this time.
Yeah, no, I think in some ways you're probably ahead.
You did lodge a submission that we looked at earlier because you weren't here, and it had similar sorts of things relating to what was in Chapter 2 of the existing plan, And what you talked about in that submission was you were encouraging council to actually defer doing anything else until the RMA was sorted out. And we had deferred the plan for about 18 months, waiting for government to come up with something, and it's at least another 2 or 3 years away. And the plan that we've got at present is so out of date, constraining development, that the council saw a need to proceed now.
I'm glad you came so well informed, because I'd forgotten what I'd originally submitted on, so I can see now why I'm sort of into this group, and that possibly the suggestion still stands is that, given the fact that the rewrite of the RMA has been communicated, it doesn't matter what you do, it will affect the ultimate outcome of the Gores plan, whether out of date or not.
I expect we'll actually be finished the plan process before government puts a new act out, and it'll probably take 18 months after that before it gets passed.
But regardless, if you're drawing up a district plan which is until it's reviewed again, then wouldn't you wait on this legislation? I'm running into the same problem with Environment Southland over the Resource Management Act, and we just can't wait for the rewrite simply because, you know, basic maintenance or to do with rivers, etc., is stumped with the current writing at the RMA. And so, you're not the only ones, but yes, you're not the only ones that are ploughing ahead, but all I know is it's going to cost more in costs down the stream, and what's the hurry?
Can I ask one more? And it's looking at what you gave us today, 3 paragraphs up from the bottom, that one, and right at the end, your last sentence there is saying to stop the possibility of compromise if any activity currently allowed, is denied, and that you're looking for no imposition of additional consenting costs. What I wanted to double check was, so what you're saying is, if an activity is currently a permitted activity, so you don't need a resource consent for it, that's what you want to be the case going forward. But do I also take it that you accept there's some role for consenting, you just don't want new consenting requirements?
I think there's a shift, and it comes out of the current agreements that you have through the Runanga under the Sculptural and Landscape Assessment Plan. That it's no longer, and whilst the original acknowledgements were for the Mataura River, this particular sites in Gores, the Tutorau Monument and the Mataura Falls. But now there's another change again to, in fact, Ngāi Tahu having an affinity with the whole of the district. This wasn't sort of an occupational right so much as almost a sort of a nomadic affinity, because they came through here and they could have been wildfowl or fish or whatever it was. I mean, anyone can claim that affinity, and I did sort of loosely refer to the Highland clearances there, saying, well, you know, nothing was in concrete for those people that were driven off their lands either. Not to say they're under the same jurisdiction, but as an example, how history treats people who are dispossessed of their land in a real sense, and that they may well have had title or whatever. And what I'm saying, that by council loosening the rules again to give Ngāi Tahu or the Runanga or whoever they represent a broad brush interest over the whole district, almost over the top of people's freehold title, is a step too far.
So Hugh, what would you see as an alternative? Do you think there's only those 3 sites of significance for Māori?
Well, the stories get distorted over time, and you know, I don't want to be too disparaging, but the narrative goes that it was through the observations of a Maori chief from Croydon Bush that he noticed that there was birds feeding at the Matara Falls. Well, can anyone see that far? Could anybody observe from that distance a flock of birds? And if the Maori were familiar with the catchment, they would know the existence of the lamprey at the falls a long time prior. So the stories keep changing and whatever, but so we need to acknowledge what we know, which is the monument and the falls, but don't get over generous in the respect that subsequent to the treaty and subject to the traversing of Maoris either to gathering grounds or back to Ruapuka Isle or wherever, that the Land Transfer System and the Land Act have come into being, and they've conferred rights on people who expect that to be respected. Absolutely. And back, I think that helps answer your question, is that given the fact that landowners have got the peaceful and enjoyment use of their asset, that needs to be, it has to be absolutely respected. And any changes you're going to make with the district plan, it's not acceptable. To the level, we would feel so strongly about this that we would take an action against the council for assuming that this direction of travel with the Runanga somehow holds more prominence than what freehold title is. And I've gone back to the Ngāi Tahu Claim Settlement Act, and I can repeat that paragraph above, if you like, which turns around and says it has in itself of granting, creating or providing of any estate or interest in land. So it's there as a what do they call them? Limitation of rights. It's there in black and white, and we want that with help considered as you write the plan.
And that's probably a key focus for what the hearing in December will be about.
Do I have to come back?
Well, in terms of the issues that have been covered, the submission that you've lodged is more of a general nature, and probably like many people in the community, liaising with federated farmers is probably the appropriate way to do it, because there's they're coordinating a number of the people on this issue.
That might well be the case, but you know, what Parliament does with submissions, the minute there's one that looks like 1,000 others, you say it's one. So if I want to go and bat for myself, I'll do it.
When you say we would take action against council, are you meaning yourself, or are you meaning like
well, I would think a lot of
federated
people would be
farmers?
motivated like I am.
Yes.
You know, the thrust of this district plan to me is, what sort of district do you people want going forward? And to me is the direction of travel of this significant and areas of significance to Maoris is dividing the district. And we're not just looking after taking regard for history. We're trying to lay, you are trying to lay a plan out there that's going to attract people, more immigrants who want to participate and work in the district. And we don't want a district there that's got promoting division.
So on your second page, you're pointing to the UN Declaration of Human Rights. And of course, the UN does have declarations that are specific to Indigenous people and rights to customary access, that kind of thing. I think the idea that we're talking about is not, as I understand it, any demand for access to privately held land. I think what's being put in front of us is more to do with the Indigenous biodiversity aspects that support Mahinga Kai, for instance. And if you think about the amount of privately held land involved in the district, if you're looking after things that live in water and things that live, Indigenous things that live on land, how do you see that happening in the absence of rules or recognition that those things do have a relationship with mahinga kai practice?
Look, it's easy to have a world view of what the country was like in the early part of the 19th century, and you know, we know that there was mowers, for example, that are now exterminated. So in terms of mahinga kai, I mean, the reality is that most of us go to a supermarket for our shopping, and invariably it refers to seafood, whether it be or whitebait or oysters or blue cod or whatever, and I haven't actually struck anyone yet that eats these eels at Matara, but be that as it may, we're acknowledging that exists, but we're not saying, well, it's the perch or the eels or anything other. I mean, that we're in New Zealand, aren't we? And everybody gets a fair crack at this. So that hasn't quite answered your question, but I think you know where I'm coming from.
No, not make a point, only questions. Hugh, thank you for coming along today. We've listened and we will absorb. So thank you. And that brings us to the end of what we're dealing with in public today. So I'll close the hearing until 9:30 tomorrow morning.
So in the chat part of it, I was privileged when I was in the States to go to a place near in Louisville,